Welcome to the case summary for Davis versus Washington on 4lawnotes.com. In this case, the defendant was apparently beating his girlfriend, and she placed a 911 call while he was beating her. There was a conversation that took place between the 911 operator and the girlfriend while this was taking place. Then the defendant left the scene, and the police officers arrived on the scene shortly afterwards. So they were able to testify that she had fresh injuries, but they couldn't testify as to how she got those injuries. The girlfriend didn't show up for the trial to testify against the defendant, so the only testimony of evidence was the conversation that took place on the 911 call. And so the defendant challenged his conviction that the 911 call was not testimony, and the admission of that as evidence was a violation of his rights under the Sixth Amendment's Confrontation Clause. So the issue is whether statements are considered non-testimonial for purposes of the Confrontation Clause when those statements are made purely to enable police assistance to meet an ongoing emergency, such as statements made during a 911 call. And the U.S. Supreme Court held that the statement identifying the defendant during the 911 call was not testimonial. A 911 call is not designed to establish or prove past facts, but to actually describe circumstances requiring police assistance while the caller is speaking about events as they're actually occurring while she's facing an ongoing emergency rather than describing past events. So the statements were necessary to resolve the emergency rather than to investigate events. And that concludes this case summary for Davis versus Washington on 4lawnotes.com.